But to borrow money, to say to go pay it back, and you don't, it's like you say, how would you feel? You'd want to break his legs. But I'm not a violent person, as I've not threatened him in that way. I ain't said it to him.
Let me be clear, sir.
Other people have done it.
Talking. If I lent somebody money and they didn't pay me back, I might be very cross.
I'm cross.
I know you're cross. I certainly wouldn't suggest anywhere that I would want to break somebody's legs. Do you understand?
I've not told him that direct, but...
Well, I presume, then, you've suggested it indirectly.
No, I've thought about it, but I've not done it.
No, I understand you haven't done it, otherwise you'd be in prison, sir. No. But one of the things that you just disclosed to me gives me a deep suspicion that at some point you have said to somebody close to Chris, who you intended would communicate this to Chris, that if he didn't pay you back, you would break his legs. Look at me, sir. I know. The reality is, don't you tell me porkies, there has come a time when you've said to somebody that would communicate it to Chris... It
wasn't a threat, it was just something to frighten him, hoping that I'd get me money paid back.
Exactly, sir. You deliberately used language that would frighten him.
Yes.
Who did you communicate that to, sir?
No.
Was it your niece?
Yeah, my niece was on his case.
What language did you use, sir?
Well, I didn't say
Was
anything.
it something like, if he doesn't pay it back, I'm going to break his legs? That sound about right?
Not in them words. But
not in them words, but that was implied. Correct?
And she applied...
Correct?
She applied them
Correct?
Words. Yeah, correct.
You went round to the house. You bumped into debt collectors, am I right?
Correct.
What happened, sir?
Debt collectors on the door, knocking, asking for money, and he's got debts of arrearing at that property of over 1,500 quid.
He's got debts everywhere.
I know it. Well, I know now.
Am I right to say that you've provided my court with letters that are addressed to Chris?
From debt collectors.
Just pause. You went to his address...
Well, not where...
Talking! At his address, you discovered letters that were addressed to Chris in respect of his debts. They weren't addressed to you. You took those letters. Sir, these are letters that are addressed to you, I am told. Do you give me permission to inspect these letters?
Yes, Judge.
Thank you very much. Can I have a look? Can you please... Sorry, Michelle. Can you hand these to Christopher? These are debt recovery letters. Had you ever seen them?
No.
That's because they'd been taken by Trevor. What right do you have to take somebody else's mail, sir?
Well, I just went round to the address...
What right do you have to take somebody else's mail?
I've not got...
What right do you have to take somebody else's mail, sir?
Probably no right.
Your claim today is for £500 for non-payment of an enforceable loan, correct?
Correct.
You're also seeking £125 of the offer of interest.
Well, the interest can get wiped.
You have a counterclaim, sir, which I should tell you, until cross-examining Trevor, I was going to dismiss straight away. Having heard the evidence, I'm now interested in it, but you're here without a lawyer. Do you understand?
Yes, Judge.
So I need to assist you. You're claiming £200 for emotional distress. Now, you've not seen a counsellor or a therapist or anything of that kind as a result of his behaviour, correct?
No, Judge.
However, am I right that you feel harassed, bearing in mind that you have been the victim of a very serious threat of violence?
Yes, Judge.
And am I also right that you think that the trespass to your property, especially your mail, is very significant indeed?
Yes, Judge.
And you would like to form a counterclaim based upon those two legal principles?
Yes, Judge.
No.
Now, just to be clear, your claim is not restricted to the £500 principal sum of the loan. You also have an additional amount as well you'd like me to consider, correct, sir?
Emotional distress.
Emotional distress?
Yes.
And how much is your emotional distress worth, sir?
£2.5 grand.
2,500. Be quiet. Please, sir, could you explain that to me?
The reason is that I've been considering worrying about this money not coming back to me. I've been rushed up to Basingstoke Hospital under a heart attack.
Because of the worry?
Yeah. And now I'm under a load of medication, pills.
I accept that this has caused you some distress. I accept it's caused you worry. You say the fact that this gentleman hasn't paid you back has caused you worry to the extent that you're entitled to sue him for £2,500 for the physical effects of him not paying back your debt.
I was fit enough before, no, I'm not now.
Understood. Trevor, Chris, there are two parts of this claim. Trevor, you are suing Chris for non-payment of a loan. In nearly all cases where you know an individual, they're a family member or a friend, a loan is not recoverable because you don't have an intention to create legal relations. In other words, the parties didn't intend that in the event the person didn't pay it back, you were going to end up in court. The way that you rebut that presumption is by putting it in writing. In this case, you didn't have anything in writing except a text message. However, I'm satisfied by the narrowest margin that that text message was contemporaneous. In other words, it was around the time the money was handed over. What's more, even if I was not satisfied about that, Chris, you lied in order to obtain this loan in the first place. Don't be stupid. Stay and watch the best Judge Rinder moments. And I'm talking. Understood? Don't be a moron. Subscribe to Judge Rinder YouTube channel. Right now. That's an order.